Bismillahirrahmanirrahim. The second question of international law of chapter 1 is what are theories to basis of international law? What is international law? Is it true proper law? Whether it qualifies as a law? The question was in CSS exam 2005. Basically, about the theories, there are two theories as to the basis of international law. The first one is called the Austinian theory. According to Austinian theory, the international law is not a proper law and it is not a true law. John Austin is the founder of this theory. Hobbes, Bentham and Pufandorf had also supported this theory. The other theory is called historical theory, and according to Oppenheim and Starr, Hall and Lawrence has supported and produced this theory. According to them, the international law is proper law. Professor Salman gives a definition of international law. He said, international law is body of rules and principles which influence the human will to abide by these rules and work as motivating force for social progress. These binding principles are issued by the state and enforced for administration of justice. According to this definition, there are certain basic elements of law which are as a body of rules being enforced by a sovereign authority, having command and legal binding for a community of people, giving consent to enforce it, and enforcing agency to implement the enforcement of law. These are 4 to 5 basic ingredients of law according to Professor Salman that gave to certain ingredients as law. Therefore, both the school of international law about its basis, such as positive school of thought and historical school of thought, have given their arguments about the in support of their theories. According to John Austin and his other colleagues, the international law is not a proper law, and this school of thought is called positive law. In their in support of their theory, they submitted that why the international law is not a proper law. They said it has no sovereign authority like a local law, like a state law. The international law has no sovereign authority which can enforce it. They secondly comment that international law has no enforcement mechanism, executive authority. They also submitted that the legislative machinery is missing, like state parliament, state legislative institutes for local laws, for state laws. The international law has no such machinery. They also explained that the international law has no sanctions like state law. There is no political superior authority which can enforce it, and there is also uncertainty about rules of international law, no compulsory jurisdiction, limited scope. These are the basic advocacy points, basic ingredients of their theories on the basis of which they said that international law is not a proper law. On the other hand, historical school of thought, historical school of international law, which supported that the international law is a proper law, they were of the view that international law is true law. They discarded the argument of the positivists regarding observance of and enforcement of law. They argued that the observance and enforcement is not essential elements of law.